Thank you. Mr. Bright, and an invitation to all counsel, to the extent that you can rely on other arguments that are being presented, because some of yours are similar, please do so.
Thank you, Your Honors. May it please the Court. As Justice Solomon pointed out, liability under Section 824 of the restatement is not independent of liability under Section 822 of the restatement. And contrary to Mr. Hanlon's remarks, I know that because Section 822 of the restatement tells me that. Section 822 says, one is subject to liability for a private nuisance if, but only if, his conduct is a legal cause of an invasion on another's interest in the private use and enjoyment of land, and the invasion is either intentional and unreasonable, or unintentional and otherwise actionable under the rules controlling for liability for negligence, recklessness, or involves abnormally dangerous conduct. So Section 822 of the restatement answers the question of, is 824 an independent section of the restatement, or is it dependent upon liability first being established under 822? Because it says liability attaches for a private nuisance if, but only if, you meet these qualifications. Section 824 of the restatement then goes on to further define what type of conduct can be actionable as a nuisance, and it does admittedly include failing to abate a nuisance in addition to causing the nuisance. But the question before the Court today is whether or not there should be two standards of liability. One that we would apply under Section 822 of the restatement for causing the nuisance, and a completely different, much more stringent standard for failing to abate a nuisance. Because if the Court accepts the plaintiff's arguments, the Court would essentially be imposing strict liability on people who fail to, quote-unquote, abate a nuisance within, according to Mr. Hanlon's interpretation, a reasonable time. That is not the law of nuisance in this state. The Restatement of Torts, Section 822, has been cited by this Court numerous times. The law of nuisance in this state is well settled. There is not, the only basis of strict liability in a nuisance claim involves claims for abnormally dangerous conduct. Mr. Hanlon nor the plaintiffs are attempting to argue that this is an abnormally dangerous activity situation. That was part of my motion in the trial court to Judge Bauman, where I specifically raised count 2 of their complaint was for strict liability based upon abnormally dangerous activities. I moved to dismiss that count. Mr. Hanlon did not submit opposition to that, and in fact, that oral argument stated to the judge something to the effect, I think the quote was, actually I have it in front of me, Your Honor, we don't oppose the arguments concerning strict liability. We haven't submitted any opposition, just so you know that. So there's no question in this case that this is not strict liability. This case, if anything, would have to be a negligence standard, because the intrusion, as found by the trial court, and as is not disputed in this case, is an unintentional nuisance. So we have to look at Section 822, and if liability can attach, then Mr. Hanlon is correct that we could be liable for failing to abate the nuisance. But we're not strictly liable for failing to abate it if we're not liable under Section 822. And that's the essence of their argument. Now, their argument is based upon, I think, two misunderstandings of the law. The first one I've already covered, which is that Section 824 is an independent section that imposes essentially strict liability. The second, I think, misunderstanding is that they look at the language pertaining to reasonableness of conduct. And their position, at least in the lower courts, although I haven't heard much of it today, was that they only had to prove unreasonable conduct. And that's not correct either, because the restatement, again, Section 822 says unreasonableness is the standard for intentional intrusions. And there's no argument in this case that this was an intentional intrusion. Mr. Hanlon never made the argument, and I don't think the facts would justify it. Now, Justice Lowitz has raised Section 839 of the restatement, which I am familiar with. And if the court looks at that section, it's entitled Possessor Who Fails to Abate an Artificial Condition. There is a hypothetical, it's an illustration in that section of the restatement that deals with a case not factually similar to this case, but identical to this case. It involves one homeowner whose underground storage tank leaks and pollutes the neighbor's property, pollutes his drinking water. And the illustration provides that A is the one who owns the tank. When A learns of this, learns of the fact that the contamination has occurred, he immediately removes all remaining oil from the tank, but the oil already in his land continues to migrate on the plaintiff's land and pollute his well. According to the restatement under Section 839, A is not liable to B for failing to take action to remove the oil already in his land, since that would not be practical to do so.
My question to you is whether or not the restatement is outdated when it makes that statement, because we know now that it is practicable to remove dirt, contaminated dirt from people's property. It was being done to the homeowner's property, the neighboring property, so why would it suddenly become impracticable to remove the dirt on the second house down the road whose dirt now has found to be contaminated by the oil?
It may be practical, although I don't think that addresses the issue. The issue here is to looking actually at Section 822 of the restatement, and because it further back, which I didn't read in the illustration, they talk about the fact that there was no negligence involved in A's use or ownership of this tank.
Maybe not initially, but once they know that it's leaking, and this illustration makes clear, once they know it's leaking and the remaining oil in the tank leaks out, damaging dirt, it assumes that that is something that should be remedied. Then the illustration seems to make a difference in terms of, you know, what can be done to practicably to address that wrong. And perhaps I'm suggesting to you, tell me otherwise, is the restatement outdated when it assumes it's impracticable to now remove the dirt?
I don't think it's outdated because impracticable in the terms of what we're looking at for a nuisance standpoint. Abatement of a nuisance involves stopping whatever's causing the nuisance. So if we're talking about an underground storage tank that's leaking and petroleum is going onto the neighbor's property, the only thing that you can really do to stop that from occurring is to remove the tank and take the oil out of the tank.
Yeah.
Now there are
No,
other...
it's talking about removing the dirt that's already been contaminated.
The hypothetical?
Yeah.
I think it's just talking about removing the tank and then therefore stopping
No,
the cause of it.
it's assuming, as
No.
Justice Levecchia is saying, that the tank has spilled oil onto land, the tank is removed, but yet the oil in the land either is or is not continuing to migrate onto someone else's property. And when it's not practicable to remove it, then there's no liability. But when there is, because there's continuing migration, then it assumes there is liability. So, so assuming I'm correct about that,
So
do you have
I'm reading it.
any experts or science to say that it was not continuing to migrate after the U.S. The tank was removed or fixed?
Well,
Go ahead.
this hypothetical assumes that it was actually continuing to migrate, but still says that there is no liability. But I understand Your Honor's...
Only because it says because it wasn't practicable.
Right.
But what Justice Levecchia is saying, if your people could come in and remove the dirt, okay,
Which we
then,
did.
and therefore stop the migration, then it would seem to be practicable.
Yes, and we did that, Your Honor. And there are other provisions of law, such as the Spill Act, which we complied with. And another basis of their complaint was Spill Act liability, which was dismissed, again, unopposed on my motion for summary judgment because we complied with our obligations under the Spill Act. As it relates to whether or not this is outdated, I don't think it does, because I think you have to look at Section 822, and the question there is causing the nuisance.
So
In other words-
let me ask you this. I'm trying to understand this. So let's go back to the tree example. We have a superstorm, and the trees on my property, which are huge, fall onto my neighbor's property and also onto his pool during the summer. Okay, so he can no longer use his pool. My trees were sturdy. I did not negligently maintain them, but now they're on someone else's property. Do I have no obligation to remove them in a timely way?
Under the law of nuisance, I don't think you do, Your Honor. Perhaps that would be more of a trespass, because now we're talking about something that's gone from your property and is now occupied.
Okay, whether I call it a
Whatever.
trespass or a nuisance, do I have any sort of obligation based upon a standard of reasonableness to remove those trees in a timely way so that my neighbor can have the enjoyment of his property?
No, I don't think you do, Your Honor, because...
Well, that's a crazy law then. It
Well,
sounds
Your
to me.
Honor, I mean, keep in mind that when we're talking about a nuisance, we're talking about something that's occurring on your property that's affecting your neighbor's property.
For one moment, I want to forget how you're categorizing it. I don't care if it's trespass, nuisance, or some other theory of the law. Are you telling me there's no relief to the homeowner whose property can no longer be enjoyed because my trees are now blocking his access to his pool.
What I'm saying is that if your intrusion was not intentional and was not negligent at a minimum, and is not considered a trespass under Section 166, which I don't think it would be considered, and as we go forward, I mean, we're
So,
sort of...
we're the Supreme Court, so these restatements aren't binding us.
I understand that,
You know,
Your Honor.
we're permitted to consider, like, reasonable rules of responsibility. Sometimes we follow the restatement, sometimes we don't.
I
So
understand.
you're telling me, under your theory of the law, there should be no obligation on the homeowner to remove the trees in a timely way?
Well, my position is that there is not, because when and understand that this is the Supreme Court, we're not bound by the restatement, although the restatement has been adopted by this Court in several cases in the past. But under Section 166, if we're talking about a trespass, it says, except where the actor is engaged in abnormally dangerous activities, an unintentional, non-negligent entry onto the land or possession of another does not subject the actor to liability, even if the entry causes harm.
Would
So
you agree that if there's negligent actions, there would be action, there would be a cause of action?
Sure, if you negligently...
This is a summary judgment. Shouldn't there have been discovery to determine whether your client was negligent or not in the failure to abate?
There was discovery. Well, the negligence aspect was, again, waived at oral argument. They didn't address the negligence. That was count one of the complaint, which I raised in the motion. It was not opposed. But the discovery was, for all intents and purposes, complete in this case. We had this was a case-managed case by Judge Bauman.
When you have a situation where these cases are so expert dependent, and everyone who's handled these types of cases knows you have to get pretty far in discovery before you have what the expert will tell you he or she needs to provide an opinion. Was this a premature grant of summary judgment
Absolutely
on that
not.
negligence issue, 822 to 824?
Absolutely not, Your Honor, because the only thing left, everything under every relevant discovery deadline under the last case management order had already been expired when the summary judgment motions were granted. Their deadline to produce an expert report had expired. They did not identify an expert. So even if we assume that I'm wrong and we say, okay, there is liability because you failed to abate the nuisance, and we accept the plaintiff's position, their argument that we had an obligation to act fast enough and we didn't. They have nothing to support that argument because this is a case of contamination in the ground. This is not moving tee boxes on a golf course or turning your music down so you don't offend your neighbor. We're not capable of immediately abating the nuisance.
Well, wait a minute. There are surrounding properties that already had been dug up.
That's correct.
You knock on the door and you say, well, not you, but the insurance companies knock on the door and say, we're going to take care of this. We've taken care of other properties. We're going to take care of this. They can just do it whenever?
If we accept plaintiff's argument, I guess the answer to that would be no. But what I'm saying is,
Well,
in this case...
are there any circumstances when they can just say, whenever?
Well, that didn't...
We'll get to it?
That wasn't the case here, Your Honor, because even though Mr. Hanlon has said, well, we're going to stand up and tell you that we can't do things fast enough because there's contamination, the record in this case is clear and it's undisputed. And the appellate division's decision cites the report by Mr. Rhodes, which talks about sampling that was occurring from May of 2007 until 2009. So there were things that were occurring at the time.
There are things that are occurring,
Sampling.
and you have a homeowner who's also living through this in this state of suspended animation. How long do they live in a state of suspended animation?
Again,
before we cross over into the land of unreasonableness?
Well, if we accept that reasonableness is the standard, which I don't think it is here, and I think the restatement is clear, but if we accept that standard, the answer would have to come from Mr. Hanlon, who would provide an expert report. His
What
position...
is the standard?
What's that?
What is the standard if it isn't reasonableness?
The standard is non-liability in this case, as found by Judge Bauman and also affirmed by the appellate
Let's
division.
go back.
That's not a
Let's go
standard,
back
that's a
to
finding.
you. Let's go
Well,
back to you, to the property owner who is the source of the contamination.
Okay.
What is their obligation?
To not be negligent.
But
Is
they
there-
still have product that has moved from their property to another's property. They have an obligation, do they not?
I don't believe they do because there was no negligence and this was an unintentional intrusion. However, as I'm saying, if we accept the plaintiff's argument, it would be a reasonable time. But the problem for the plaintiffs in this particular case is that they have no expert to support that. Mr. Hanlon said in his brief, the defendants have failed to show why the remediation took a reasonable amount of time. That's not our burden.
So
We're
I
defendants.
have an oil tank on my property, and it's ruptured, and it has now seeped down the block. I have no responsibility?
If you're
Under what?
under
I
Section
mean,
822 of the
Well,
restatement,
that's under Section 822.
Under all the-
But we do have some other statutes and law in place, correct?
That's
That
right. The
would
Spill
place
Act.
the liability on your client.
Right.
Right. So, what is their obligation? Going back to your client,
My client's obligation...
pick up the phone?
To pick up the phone, and in that instance, yes, where there's insurance available. I mean, in this case, Mrs. Ellman, my client's hands, were every bit as tied as Mr. Ross's hands, because all she can do is call her insurance carrier and put them on notice of it. And
Well, I
expect
think
them to-
Mr. Hanlon said practically that is all. We recognize that. But she would be, as the property owner, has the responsibility to clean up, correct? If she
I don't
does
believe
not
she
have the
does.
financial resources, she has a problem, correct?
I don't believe she has the obligation to clean it up because there was no negligence as found by the
How
trial
about under the
court.
Spill Act?
Under the Spill Act, obviously she was, and we've complied with the obligations under the Spill Act. And they essentially dismissed that count because they had no damages. This is not a case where the plaintiffs are left holding the bag. I mean, the remediation was over.
Tell us what an innocent third-party homeowner can do under the circumstances. What viable legal option do they have if their neighbor's underground tank has seeped over to them? Everybody knows there's currently oil that has migrated and there is damage, and month after month passes and there's no actual remediation that's been done. What viable legal option does the innocent third-party homeowner have?
In that instance, they could report it to the DEP, and the DEP could file an enforcement action against the neighboring homeowner to clean up the oil. There's no dispute here that Mrs. Ellman, through her carrier, was obligated to remove the oil.
So,
The DEP has, many cases, has limited resources, has obviously some major cleanup projects, industrial projects that it's involved with. If the DEP puts it on its back burner, the homeowner simply has to tolerate this?
Well, they could go to court and file an action for contribution towards remediation expenses to get it cleaned up. I mean,
Essentially, the question is whether the neighboring homeowner who's injured is going to have a cause of action based on strict liability against the neighbor where the nuisance was created, even in the absence of negligence, as strict liability presumes. That's really the question.
That
In
is
other
the
words,
question.
right now you're arguing the restatement says they have to have some responsibility. The neighboring owner who caused the problem either negligently acted or deliberately acted, was engaged in a hazardous activity, which having a tank is not found to be. Under those circumstances, there are different remedies. We've got to decide. What you're asking us not to decide is there's strict liability. Once the problem's caused, without negligence, without responsibility, you have to pay for it.
that's exactly correct. Your
Okay,
Honor.
and that's really the debate here.
That's, the issue before the court is whether or not failing to abate a nuisance gives rise to strict liability, keeping in mind the fact that
Forget about
negligence-
strict liability. I don't think, we're talking about after the fact, whether or not you have acted in a reasonable way, and whether or not that is careless. But that depends upon whether or not you have a duty, right? And that's why that's why we're in business, determine sometimes whether or not parties
Let's
have a duty.
reorient things too. We know under the Spill Act, your client has responsibility. That's where you want to contain it, correct? You don't want to get into another cause of action that may lead to consequential damages,
Right.
such as Mr. Hanlon is seeking
Right.
for his client.
This
You
case is
want to
only-
limit your responsibility to just remediation.
So my question to
In
you
this
is,
case, there
okay,
was no negligence,
So,
yes.
so pivoting off of that, why shouldn't a duty? You're familiar with the Hopkins case, right?
Yes, Your Honor.
So why shouldn't, under these circumstances, a duty be imposed upon you, considering notions of fairness, substantial justice, the relationship of the parties, the ability of your client to do the remediation? Why shouldn't your client, under these circumstances, have a duty to remediate within a reasonable period of time. And if you don't do that, and you permit your neighbor to suffer this long nightmare, you should be held responsible for consequential damages. Why not?
I think what the court is having trouble with, and perhaps I should have explained this a little bit better or emphasized it more, is that in this case there is no claim that Mrs. Elma was negligent. There was
You're
a
saying
finding
that-
by the
let
trial
me see
court
if I
that
can,
she
let
wasn't.
me see if I can articulate what the distinction you're drawing. You're saying that the negligence, in order to create a claim for negligence, the negligence has to be at the origin of the spill or the intrusion of the oil, and that having committed or arguably committed to do a remediation and then not gone through with it. I know you'll argue with the facts, but let's just assume that for the purposes of the argument, that does not does not constitute an act of negligence.
That's
that may
correct.
be a lack of courtesy. That may be a lack of
That's correct.
commercial reasonable behavior on the part of the insurance company or whatever. But that does not give rise to negligence. The negligence that has to exist in order to create the cause of action has to be at the origin of the oil going from one property to the other.
Yes.
Does that sum up your argument?
And I will cycle back to Section 822 of the restatement, understanding that we're not bound by it, but it does do a very nice job of clarifying the distinction, because it is a very nuanced argument between intentional, unintentional, negligent, not negligent. But Section 822 says you're
let me
liable
just-
only
let me
if.
just- Let me just follow up. So you are saying there's no basis in the law to impose a duty to remediate that does not originate in either negligence or intentional conduct in the first place.
It has to be either negligent or intentional at a minimum.
Someone may, to avoid litigation or to comply with the Spill Act or for whatever reason, offer to remediate, but the slowness of that remediation does not give rise to a cause of action for negligence, is what you're saying.
I'm saying that, and I'm also saying that in this case there is no evidence of a slowness of the remediation, even though that's what the argument you're hearing from Mr. Hanlon is. There's ample evidence in the record to show what was transpiring from the moment we learned that the contamination went on the Ross's property till the
But isn't
time
that,
that
if
the
the
NFA
question
was
is
issued.
reasonableness, isn't that a question of fact? I mean, if we get to that point where that dispute, that issue exists, doesn't it go back to the trial court, let a jury figure it out? We're not going to make that factual
It
determination.
could, but the problem in this case is that deadline to serve the expert report to support that, because keep in mind that I think you have to
Was
have an
that
expert.
part of the motion?
That is not part of the motion.
But didn't plaintiff seek to have the opportunity to provide an expert late?
Mr. Hanlon mentioned that he filed a motion to compel. I wasn't involved at that time of those issues, but
Yeah.
that there were people who refused to produce experts. A motion to compel was filed. It was denied, and that was never appealed. That motion to compel is not part of what's before the court today. So if this court decides against the respondents and remands this case, it's going to go back to the trial court. Their deadline to produce an expert is going to be expired, and how are they going to ever prove that we took an unreasonable amount of time to remediate, keeping
So
in
you're
mind that
saying
that's
the
never-
record as it stands now, based upon that determination, that they were out of time, couldn't offer experts, the record's complete, we can make that decision, it's not really a factual determination.
I think it is a factual determination that requires expert
Right, and
opinion,
where there
which
is no
not here.
expert.
That's correct.
It doesn't go back for a factual determination.
That's
Now,
correct.
let me ask you one other thing. We've had some conversation about remediation, whether, reasonable time, what's the duty, what's the obligation. And you've argued that there must be an underlying cause of action. There must be negligence or an intentional act, or negligence or an intentional act, or a hazardous, dangerous activity
Right.
opposing strict liability. Does the restatement with respect to remediation require conduct where the party responsible for remediation doesn't control the property where the nuisance exists? In other words, I thought the restatement and the comments stated specifically that obligation, that remediation obligation, attaches and has to be done reasonably where you control the property where the nuisance exists, has migrated. Is that right, or am I
Excuse me.
wrong?
Candidly, Your Honor, I think the restatement actually says the opposite, that if the transfer of land does not basically absolve you of liability for a nuisance that was created when you owned the property.
No, I mean, I'm talking about the adjacent property that was affected.
Right.
I'm not talking about the property you once owned.
Okay, I'm sorry, I misunderstood that.
Okay, I'm talking about this fact situation.
Okay.
Does the restatement talk to that, speak to that at all?
I think it does in Section 839, where it talks about if you have oil and it's not practical, if you're talking about a nuisance claim, it's not practical to remove that because it's underground and it's migrating, and perhaps it's a trespass, but I think the standard for trespass is even...
I thought it specifically spoke to control of the property where the nuisance exists, where it's migrated to. That if they, for example, if it's on your property you own now or did own, absolutely responsible to abate that nuisance, to do whatever you have to do within a reasonable period of time. But where you don't control the property where it now exists, that's different. Is that right, or did I misread it?
Not that I'm familiar with, Your Honor. Perhaps it is.
I may have misread.
I think it makes sense because, you're not in a position, Mrs. Ellman, who sold the property, by the way, long before this contamination was even discovered on the neighboring property, what position is she going to be in to go over and remediate the Ross's property? I mean, all she can do, as we've discussed, is call her insurance carrier and make the claim.
Is there anything you'd like to add to your argument?
No, that's it. Thank you, Your Honor.
Thank you. Mr. Mueller.